Good afternoon, everyone. Thank you so much for joining us today for our talk on Post-Enterprise Act Employers' Liability Claims. My name is Karina Manson. I'm one of the partners in the personal injury team at BTO, and I'm going to chair today's discussion. I've got a few housekeeping matters before we begin. I'd appreciate if you could all stay muted during the call unless you're asking a question. I can't wait until the Q&A session at the end. If you do have any questions, then please feel free to use the chat facility, or if you want to speak at the end, then feel free. Finally, the webinar is being recorded today, so you should switch off your cameras unless you want to particularly appear on that recording. We've got two speakers for you today. We've got Mark Hastings and Lewis Richardson, two of our solicitor advocates. Mark Hastings is a senior associate in a personal injury team. He deals with complex claims arising from a wide variety of accidents, including road traffic, employers, public and occupiers liability claims. And we've got Lewis Richardson, who's an associate. He deals with the same type of claims, but he also has a special interest in disease claims and is a member of our disease team. So what I'll do now is I'll pass it over to Lewis to kick off our talk today, and I'm sure you'll find it very interesting. Thank you.
Thanks, Karina. Yes, as Karina says, today's webinar is about the impact of the Enterprise and Regulatory Reform Act on the common law duty of care and the implications it has, and we'll be looking at some various aspects of that. Just wondering where we've got some slides to show as well. Not sure where they've gone. But while we're waiting for those to appear, I mean, I'm going to be discussing looking at the background of the. Excellent. There we go. Thanks, Marianne. So yes, the content of today's talk is looking at, first of all, the Enterprise and Regulatory Reform Act and the six-pack regulations, other forms of employers' liability, the approach of the courts, and risk assessments. I'll be discussing the first two parts of the presentation, and Mark will be looking at the last two. So looking back at the Enterprise and Regulatory Reform Act, first of all, the operative section 69, which sought to amend Section 47 of the Health and Safety at Work Act 1974 to remove the provision that breach of the health and safety regulations would lead to a finding of liability in personal injury actions. That was introduced following government review of health and safety legislation, and there was a perceived unfairness about how liability could attach where there was no obvious fault on the part of an employer. And that's probably demonstrated most aptly by Stark and Post Office from 2000, where although an injury had been caused by either metal fatigue or some manufacturing defect, but could not have been discovered by a reasonable system of inspection. So in short, they fulfilled their duty of care to the claimant, but were still found liable. Section 69 of the ERRA sought to rectify that and went actually further than they probably needed to, and in the respect that it doesn't just disapply the regulations for strict liability applies, but also but any breach of the regulations. So as you'll be aware, the health and safety regulations cover an enormous gamut of workplace accidents and incident or workplace activity. So you've got the traditional six-pack regulations from 1992, which deal with the health and safety display screen equipment, provision of use of work equipment, personal protective equipment, manual handling, etc. But there's also a whole range of other regulations which cover a number of different specialist areas, but all now gone away, or at least they may have. There's the potential that the new regulations still have direct effect, And unfortunately, I'm going to have to mention the B word, Brexit, here, and say that despite that Brexit happening, that the EU regulations will continue to have direct effect in terms of Section 3 of the European Union Withdrawal Act 2018. So you have an argument that could potentially arise where employees of emanations of the states, police, local authorities, health boards, could try and rely on the regulations to establish liability against their employers. However, I'm not seen anyone try that, and it's unclear right now as to whether or not direct effective EU regulations, how long that will continue. In addition, to be really useful to the claimant or pursuer, the EU regulations have to be held to impose a stricter duty than those that the UK government's brought in by statutory instruments. So it remains to be seen whether that would be the case or not. So that's a brief overview of the Enterprise and Regulatory Reform Act and its effects. And it's now worth considering, what other forms of statutory liability and what other forms of liability can arise in employers' liability claims that we might not have seen before. So in this respect, I'm going to be looking at the Employers' Liability Defective Equipment Act 1969, the Occupiers' Liability Scotland Act 1960, and also a brief overview of some potential contractual claims which could arise in the employee-employer relationship. So looking first at the Employers' Liability Defective Equipment Act, that was a relatively short act, just a couple of sections. It was introduced, it was introduced following the case of Davy and New Merton Board Mills, where an employee failed to establish liability against his employer where an injury was caused by a latent defect in a piece of equipment that would not have been found by inspection. Parliament disagreed with the decision of the House of Lords in that case and introduced this statute to remedy what they saw as a defect in the law. So this act hasn't really been referred to very much in recent times due to the importance given to the provision and use of work equipment regulations, but it's expected to arise more readily now. So essentially, as the slide states, that's a section of the Act, it will apply where an employee suffers personal injury in the course of his employment in consequence of a defect in equipment provided by his employer for the purpose of the employer's business, and where the defect is attributable wholly or partly to the fault of a third party, whether identified or not. And in that case, the injury shall be deemed to be also attributable to the negligence on the part of the employer. And that's without prejudice to any arguments you might have in respect of contributory negligence or remedy by way of contractual indemnity or contribution action. So really what you're looking at here is that there has to be a defect, there has to be work equipment, and there has to be fault. Usefully, the Act defines several of those important terms. First, it defines employee as a person who is employed by another person under a contract of service or apprenticeship and is so employed for the purposes of a business carried on by or that other person, and employer shall be construed accordingly. So arguably, that provides a more restrictive definition of employee than would normally be the case in an employer's liability claim. So that's worth considering if you receive one of these. Secondly, equipment, and that's held to include any plant and machinery, vehicle, aircraft, and clothing. And fault is held to mean negligence, breach of statutory duty, or other act or omission which gives rise to liability in tort in England and Wales, or which is wrongful and gives rise to liability in damages in Scotland. So unfortunately, defect is not defined in the Act, but has been held to mean it includes everything which renders the plant, etc., unfit for the use or which it is intended when used in a reasonable way with reasonable care. So it's important when considering a claim under this Act, what was the work equipment and what context was it being used? Because whether liability would attach can depend on the circumstance, or whether there's a defect can depend on the circumstances in which the work equipment is being used. So in some circumstances it may not amount to liability, whereas in others it would. So fault is rather, well, it keeps the standard common law duty of care. So the pursuer still has to attribute fault to someone in order to establish a claim under this Act. And work equipment also, bearing in mind that that's a rather wide definition that's given in terms of the Act, and that has been subject of judicial commentary. So considering that further, Lord Oliver in Coltman and another against Bibby Tankers held that the purpose of the Act was manifestly to saddle the employer with liability for defective plant of every sort with which the employee is compelled to work in the course of his employment. I can see no ground for excluding particular types of chattel merely on the ground of their size or the element upon which they are designed to operate. And that was a case that dealt with whether a ship was work equipment in terms of the Act or not. So you can see that's quite a wide definition that's been attributed to it. However, there may be some restriction on that given the decision by Lord Maxwell in Locke against British Leyland UK Limited, where he held that work equipment does not cover pieces of machinery such as the actuator in the hands of employees for the purposes of being worked into larger articles in the course of manufacture. So the work equipment in terms of the Act may have a slightly narrower definition if you forward Lord Maxwell's reasoning. However, that decision is quite elderly now, so it remains to be seen whether a court faced with the same question would come to the same conclusion now. So you're faced with a claim on the basis of this Act. What defences can the defender really come up with in terms to protect their position? Well, first of all, as I've already said, the pursuer must still establish a fault with the equipment which caused his injury. And that could be extremely challenging given the technical nature of a lot of work equipment and the difficulty in establishing what exactly went wrong with it and how that fault occurred. However, the pursuer might not have that high a burden to meet if the court was to follow Lord Moncrieff as he said in McFarlane against Thompson, that provided that it is proved that some defect in the machinery or plant caused the accident, not necessarily to show the precise nature of that defect, and an onus is thrown upon the master to show that the defect was one for which he was not to blame. So it's possible that the court, when considering whether there had been fault or on the part of any party, could take a rather lax approach to the evidence and simply hold that if there had been a fault in the machinery, that it was then on the defender to try and establish an explanation that didn't occur due to someone's negligence. Now that, in the case of this Act, that might put the defender potentially in a very difficult position, because if it's a third party that's done something to their work equipment or you've bought it off someone, then your knowledge of their processes would be maybe extremely limited. So your ability to defend the action could be curtailed. It's also worth noting in respect of the Act is that it immediately raises the prospect of obtaining a contribution from another party. Whether you'd be successful in that or not depends on the evidence, but if you are seeking a contribution from another party, the defence needs to be pled particularly carefully, because in the inner house held in Edwards against Butlins, that the defender had effectively or had admitted that there was a defect in the work equipment and liability attached on that basis. This is despite the defender being successful at first instance at proof before the Lord Ordinary in the inner house holding, well, your pleadings are such a state that you essentially seek relief against a third party, and by doing so you admit that that the piece of equipment was defective. So on that basis alone, we can say that you're liable. So it takes care to be very careful about how you plead your defences in cases brought under this Act. So that really brings an end to discussion of this Act. And it's worth considering one other piece of statute which can have a place in employers' liability claims, and that's the Occupiers Liability Scotland Act 1960. Now, clearly that has a wider application than to only employers' liability claims, but there's no reason why an employee couldn't rely on the terms of the Act. And you'll see it's the sections set out there with the operative parts bolded. Now, the operation of the Occupiers Liability Act could probably be a presentation in itself, but I'll say some brief things about it. First of all, it's arguable that the Act simply restated the common law position that an occupier has to take reasonable care for someone coming onto their land or onto a place which they occupy, because ownership isn't necessarily determinative of that. And the cases which arise under the Act can probably be split between failure to safely construct / change the premises and also a failure to properly inspect the premises. And in carrying out either of those two categories, defender must take as a duty to take reasonable care, and occupier has a duty to take reasonable care for anyone who might come onto the premises. So that's something that the pursuers could potentially use, rather than the workplace regulations, which are now no longer able to rely on in themselves to establish a liability. So that really covers the two statutes which I think still have application in a post-ERRA world, but it's also worth considering whether there are any other potential types of claim, and that might arise from a contract of employment as an implied term that the employer and employee will act in a way which seeks to preserve the continuing relationship of trust and confidence between them. Is it possible that a defender could breach that in such a way as to found a personal injury claims? You'll see that that term of that contractual claim is sometimes used in actions of harassment in the workplace. There's also an implied term that the employer must take reasonable care for the employee. It's questionable whether that takes the employee any further than they would under just a common law duty of care in general, but it's another avenue that a pursuer could seek to pursue if they chose to. And lastly, is there a potential for an implied term for compliance with health and safety regulations? It's a criminal offence not to breach the regulations. So could it be said and could it be argued that there's a contractual obligation on an employer to follow health and safety regulations? Now, I've not seen anyone argue that point, but it's a potential avenue where pursuers could seek to invoke the health and safety regulations even after the Enterprise and Regulatory Reform Act has taken effect. So that's a brief overview of where I see the relevant, still the relevant statutes which are in force, which could be used by a pursuer to try and found liability, even in the absence of the health and safety regulations, and in particular the Defective Equipment Act imposes strict liability on an employer even where they haven't necessarily been at fault themselves. So that's an important part that's probably the most important statute to bear in mind in appropriate claims. But it's not just clean sailing for the pursuer to establish a claim under that Act. So I think that brings an end to my part of the presentation, and I'll pass over to Mark so he can carry on.
Thanks very much for that, Lewis. Right, well, thanks very much, everyone. Well, it appears really to me that it was cases like Stark against the Post Office, as Lewis mentioned, and also cases like Blair against the Chief Constable of Sussex Police. You might all remember the motorbike incident with the provision of the boots and whether they were appropriate or not. It seems to have been those type of cases that the government of the day was seeking to really to address when it enacted the amendment to Section 47 of the 1974 Act. But prior to that, such was the reliance on the regulations, several of which, as we all know, contain strict liability, that the common law concepts that we now all have to grapple with, reasonable foreseeability of harm, scope of the duty, breach of that duty, they didn't feature, if at all, in EL claims prior to around 2013. So really, where are we just now, and where do we stand? So the slide I've got showing is the key points I would say we all need to be thinking about here. I think it's fair to say we've gone back to the future, and when you're faced with one of these claims, my starting point is to go back to basic principles. I suspect in most, if not all, EL claims, the existence of a duty of care is going to be taken as read. I think the question to think about is, well, what was the scope of the duty owed in the particular context that the incident is said to have taken place? What was the employers required to do in that setting? And that has to be tested objectively. The next point I would say to think about is proximity, and that's the relationship between the parties. It's easy to see how that might be established in an employer's liability setting. It doesn't equate, obviously, to physical proximity. It's more a reference to the relationship between the parties, and ultimately comes down to a question of control and who was directing the work operations. The next point is very important, and it's about foreseeability of harm. Was it reasonably foreseeable to the employer that if they failed to do something, providing equipment, for example, that harm would befall the employee? That speaks to the issue of whether the risk was known and whether it was foreseeable, and then feeds into an assessment about whether the duty was breached in some way, i.e. an omission to provide something, maintain something, for example, PPE. That then flows into a question about whether the breach caused or materially contributed to the injuries sustained. Now, that's an application of the factual causation but-for test, or the material contribution test, which you would see more often in disease claims. I suppose the point I have is that it's a step-by-step process that you have to go through on each occasion when you're presented with one of these claims. So what approach have the courts been taking? Well, as Lewis said, the regulations, they haven't been repealed. We certainly can't forget about them. They only confer criminal liability as being opposed to being directly actionable in civil claims. The regulations they are there, they still need to be adhered to, and employers are bound to know the statutory duties that apply to them. It's been argued in a couple of cases, both north and south of the border, that the existence of a regulation itself demonstrates that harm is foreseeable, and what that relies on is Boyle against Kodak. And you'll see I've put a quote from Lord Reid on the screen, where he says back in 1969 that employers are bound to know their statutory duty and take all reasonable steps to prevent their men from committing breaches. What I'm sure you see in practice, and certainly we see, is that in a number of pre-litigated and litigated cases, the correspondence refers to breaches of the regulations as now informing the position at common law. Now, clearly, if a case proceeds to proof, as some have, as we'll go on to look at, the pursuer is still entitled to refer to the regulations. What I would say is that establishing a breach of statutory duty doesn't always necessarily mean that that will equate to negligence at common law. You can see the example from Stark, that Lewis mentioned earlier on. The difficulty in practice, I would say, is that demonstrating a breach of statutory duty can often be persuasive for a judge or sheriff when considering whether there's a concurrent common law breach of duty based or derived from a breach of statutory duty. Now, evidently, the HSE approved codes of practice themselves have an evidential value going forward, and indeed I would say help to define and inform the scope of the duty that might be owed at common law. What I would hazard is that if Parliament back in 2012-2013 had intended to cast aside the body of HSE legislation, it would have been repealed. Now, that would have caused a problem in the day of compliance with EU law. Perhaps the best way to look at Section 69 of the ERRA Act is to think of it as blunting the clause of a lot of the regulations that flowed from the various EU directives. Nonetheless, is it always going to stay this way? Well, one of the points of Brexit, if you put all your political persuasions to one side, it was ostensibly to allow the UK to take back control of its own laws and diverge from EU standardisation or harmonisation of safety standards where it saw fit. Now, that hasn't filtered through to HSE legislation, as Lewis pointed out, the EU Withdrawal Act, the regulations will continue to have force. But one point that struck me was, it was only 3 days ago, Grant Shapps, the Transport Minister, announced plans that the UK is going to legislate to avoid the impact of VNUC. And for all those who are lucky enough not to know what VNUC was about, that was a decision from the ECJ a couple of years ago, which required now a far broader range of vehicles to carry insurance, to include those being used off-road, buggies, quad bikes, things like that. But it also extended the duty to have insurance for use on private land. Now, the Road Traffic Act only applies to use on public roads. One of the driving factors here appears to have been the saving to the UK insurance industry and jobs, and the avoidance of increased premiums and increased risk being taken on. Now, clearly, that case only applies to the motor industry, but if I was to quote the Scorpions, is that signs of winds of change? I don't know. There's tensions obviously between the UK government and Scottish government on their respective alignment to the EU. Could that manifest itself in Scotland attempting to really go its own way at some point? I suspect not, for as long as the union persists. I really say that and think that for really 3 reasons. Well, one, the regulations were derived from the 1974 Health and Safety at Work Act, which is a piece of UK legislation applicable to the full UK. So doubtful whether the Scottish Parliament could unilaterally alter that. Secondly, they didn't seek to address the ERRA Act in 2013 when it came into force. And thirdly, and probably more importantly and practically, it would be manifestly unsatisfactory to businesses and employees for there to be potentially different legislative standards on safety north and south of the border. So for all of those reasons, I think the UK will hopefully keep step as a union with regard to standards of safety. So with that broadly being said about the court's approach, let's look at some cases. Now, you might have heard about Gilchrist. Gilchrist involved a lady who was a shop assistant. She fell 7 feet from a Dalek. Now, a Dalek wasn't something out of Doctor Who, though it's difficult to see how you would stand on one of those. Dalek was a platform. She fell from that, injuring her ankle. Now, her claim failed, but what's probably more important is the propositions that were put forward by her counsel and accepted by the court in terms of how to grapple with what standard of care would be applied and how you would continue to use the regulations. Her arguments were really that, one, employers remained under a duty to comply with health and safety regulations. I think we could all probably agree with that. The duties set out in the regulations informed and defined the scope of the duties at common law. I would say yes to a degree. Thirdly, she argued that an employer who breached a regulation could hardly have been said to have acted reasonably. Again, that might be fair comment, but what went on to be submitted was the existence of a regulation demonstrated that the harm was foreseeable and that breach of a statutory duty was ipso facto evidence of negligence. I think that's perhaps a more problematic concept, but there is a certain attraction to that if you are pursuing these cases. Now, the judge accepted those submissions and the impact of Section 69, principally because the defenders didn't make any contrary submissions. I'm unclear as to whether they agreed with that, the propositions being made by the pursuer. I don't know why that was. What that led to was the next case of, I'm probably going to butcher this name, but Degenis against Bourne and Sons. Now, that was a Sheriff Court decision from a couple of years ago. And what we see in that one, apart from its facts, which were obviously a manual handling case, is that the theme of the regulations informing the common law, and what the court in Degenis said was that a breach of the manual handling regulations, the duties incumbent in them were reflective of the position at common law. And so a breach would render a reasonably foreseeable risk of harm at common law, and therefore liability attached to the defenders in that case, who unhelpfully hadn't made any risk assessment of the risks involved in their operation. So we have Degenis in 2019, and then at the turn of the year, turn of 2020, we've got a very interesting case worth about £4,000, which went to proof before the All Scotland Personal Injury Court, and it was reported, as I say, at the turn of the year. Now, that's really worth looking closely at, that judgment, for the view that the Sheriff took on how to really reconcile the regulations with the fact that now we're operating in a world where the standard of care is the common law standard of reasonable care. Now in Goodwill, Mr. Goodwill was a warehouse operative. He had been employed by B&Q for many years. His role involved unloading and loading of vehicles, dealing with stock, so on and so forth. He injured his right hand when he was opening a batch of bath panels actually. He cut downwards through the sellotape onto his right hand. Why he was doing it like that, nobody knows. The claim was based on the knife being unsuitable, a different one ought to have been used, together with a lack of training and instruction on how really to use the knife itself. Now, the claim failed. The court held that there was no evidence really that the defenders had breached their duty of care to the pursuer. The fact that they had provided a different knife a year and a half later didn't render the knife in use at the time unsafe or unsuitable. The pursuer knew how to use that. There was no evidence before the court about the practice of other retailers and what they did in terms of the tools they provided. Even if there had been evidence of that, there was no evidence about any cost differential, which would be a relevant consideration given the claim proceeded at common law. So what we see in Goodwill is considerations of cost and other industry practices being taken into account. Now that represents, in my view, a change in focus, as the court would in the past really not have entertained those concepts. We can see from the judgment in Blair against the Chief Constable of Sussex Police that he said, well, in likelihood or foresight of injury doesn't matter. It's not relevant to consider whether it would have been sensible or practical to provide motocross boots to a police officer who would never use them, because the regulations didn't address issues like that. And that's a sea change from the old concept of common law negligence, which we see perhaps a move back toward in the decision in Goodwill. Now, in Goodwill, the case was quite badly pled for the pursuer, and there was a number of points identified by the defenders. An objection was taken successfully to some evidence being led for the pursuer that would actually probably have helped his case, but it wasn't foreshadowed in the pleadings, which led to the conclusion that there wasn't fair notice of the case that the defenders required to meet. Now, I wanted to put a couple of quotes from the judgment in Goodwill, just so to give you an example of the thought process of the sheriff. So you can see in paragraph 140, the sheriff says, well, look, things aren't as they were. There has to be a demonstrated negligence, and that has other consequences on pleadings, evidence and onus. And that was where the pursuer fell into difficulty in Goodwill, that his pleadings didn't set out or frame the case properly. There wasn't the evidence of other practices, cost and what the industry would do. And the onus of proof is fundamentally on the pursuer to prove the case. They can't just point to strict liability any longer and say, well, you tell me why it wasn't reasonably practicable for you to have done X, Y or Z. He goes on to say, the sheriff, in paragraph 143, that if the element is subsumed into the common law duty of care has at its source a statutory basis, the new element must be moderated to the standard of reasonable care. Now, that seems to me to be diluting what the statutes say, and it's hard to reconcile that with the continuing duty and application of them in the criminal law. So the last slide on this in terms of quotations would be this one where it, in the text in bold, what Sheriff McGowan had said was, well, you have to superimpose the common law principles onto any breach of statutory duty. So you have to start balancing factors to do with proportionality, risk, foreseeability of harm into the equation in order to demonstrate whether there has been a negligent breach rather than a straightforward statutory breach. So what can we take away from Goodwill? First, I should say it's a sheriff court case, it's not binding, but none of these cases have really gone to the higher courts, so the position remains untested. I think the first point I would say is that the court plainly is going to scrutinise, and has been, pleadings far more closely than it has in the past. What you tended to see in the past, and still to a degree do see, is a list of regulations relied on, and you have to work out for yourself why these are relevant and how they are alleged to have been breached. Now, if the thinking in Goodwill persists in cases to follow, bald averments that a defender failed to do something will not, in the absence of any other factual averments, really give fair notice of the duty, of how the duty has been breached. Now, that's a welcome development, I would say, if it's followed on from. Secondly, and we are seeing more of this in terms of the investigation of claims, the evidence is going to be important. Industry standards and cost of measures are now perhaps going to be more of a feature than they had been in the past, particularly if the case is one due to an omission or provision of a piece of equipment. On one view, the strict liability standard of care appears to have been diluted, and as Sheriff McGowan had said, you have to superimpose onto that common law considerations, and the court was quite clear in the judgment that at common law there's not a duty to ensure or insure against anything. Now that strikes against the pursuer's proposition that the common law had been breached by dint of a statutory breach. But how do you reconcile that proposition, the proposition in Gilchrist, that a breach of statutory duty is ipso facto evidence of negligence at common law, with the decision in Goodwill that that won't necessarily be the case? Now there's a tension there in my view as to how you reconcile those two competing positions. I suppose thirdly, it's a difficult exercise to deconstruct, I would say, the duties incumbent on employers in the criminal law and set them aside for their civil law responsibilities to employees. And that goes back to your Boyle against Kodak point. The two appear to me to be interwoven, and it strikes me that if Parliament chose to leave the criminal liability intact for breaches of statutory duty, there's an argument that the impact of Section 69 of the ERRA Act has been blunted. However, if the approach taken in Goodwill is followed, then maybe its teeth will show itself in the right case, or at least until authoritative guidance from other courts or higher courts, the Court of Appeal in England or the inner house of the Court of Session, becomes available. Nonetheless, it's difficult, as I say, to reconcile the proposition that, well, the law is still there, and how are we to reconcile the fact that we've now gone back to the criminal law? There's something to be said for perhaps Section 69 not being particularly well drafted. There's other cases I'm not going to mention in the interests of time, but if you have a case in the margins, I would recommend you look at Cockerell and Tonkins. They're both cases from 2018. Both dealt with how the courts would deal with claims at common law which relied on breaches of statutory duty. They're worth looking at as a sense check to what the courts south of the border have been doing, and particularly Tonkins took a very similar approach to the court in Gilchrist, north of the border, so there was an alignment on those two issues. So what can we do about all of this in terms of claims defensibility, if that's a long-winded way of saying it? Well, I think when you're investigating and analysing the merits of claims, I would say to keep the points identified on the slide in mind. If your company or your client has an operational risk caused by their business enterprise, how could it have been reduced further? Guarding in place, PPE provided, a two-man task instead of one. In reality, what steps were taken to minimise that risk? Did that accord with industry practice? What about its risk assessment? What did that have to say for itself? Was that kept up to date? What about your training, your maintenance, your inspection records? And also, has a cost risk analysis been carried out if steps haven't been taken? And can your client evidence this? I think these are all points that certainly I'm thinking about when I see these cases. And I think if before they come to me and before a claim comes in, if your insureds are thinking about these things, then maybe it could be a claims prevention tool. So that is a segue into the last issue I wanted to mention to you today, and that is the ever fun topic of risk assessments. Now, post-Enterprise Act, these have become the cornerstone or touching point for all employers' liability claims, but rarely have I ever seen a risk assessment being the direct cause of an accident or the lack thereof a risk assessment. But I think it's fair to say that if an employer hasn't risk assessed the task or its work activities, can it really be said to have discharged its duty as a reasonably prudent employer, taking reasonable care for its employees? I think you're going to be on the back foot with that one. I think Degenis is a good example of that. There's, of course, a statutory duty in the 1999 management regulations to risk assess. The duty is a continuing one. It's not static, and really an old risk assessment isn't going to be sufficient if things have moved on, practices have changed, things have evolved, unless your client can demonstrate that the risks were re-evaluated and considered to be the same with the current control mechanisms satisfactory to really deal with them. Now, the timing of your risk assessment and its validity, also the characteristics of your workforce and the vulnerabilities of the workforce really do need to be considered. I think that's probably been made even more so by, dare I say the word, COVID and its impact on those in the workplace with underlying health conditions. But that's the only mention of COVID that you'll hear today. So I've mentioned it twice, and it won't breach my lips again. So let's move on. Kennedy against Cordia. We all know about Kennedy against Cordia. The point here is really the existence of a risk assessment. There is a concurrent duty at common law to have and to assess risk. The question really for the insurance industry and for us to consider with your clients is the risk assessment or method statement suitable and sufficient? Does it cover all the reasonably foreseeable risks? How does it control those risks? Now, pursuers are going to be seeking to establish actual knowledge or constructive knowledge on the part of the employer, i.e. they knew about it, or they knew or ought to have known about it and done something about it. There's also a point for practitioners here, and that was one of the reasons why Goodwill came a cropper. If the issue is one of omission, i.e. the risk assessment didn't take account of a material factor, the onus of proof is on the pursuer to establish what that was and what would have been different had the risk assessment taken into account. Pleadings are going to be needed on that to compare the two positions, and that's fundamentally important if a court's going to be asked to make a finding on fact on this. I don't think it's acceptable for a pursuer to say there was a failure to risk assess, full stop, that represents a breach of Regulation 3. Pre-ERRA, that they might have got away with that, particularly with abbreviated pleadings, but nowadays, given the need for clarity, particularly at common law and what the duty owed is, I think they have to go further and say more about that. The positive for us is that at least your friends at pursuers firms are going to have to work a bit harder and be a bit more specific in their pleadings in terms of what has been criticised and why, even with the abbreviated pleadings. And fair notice is going to be needed and evidence supporting any propositions that your insured risk assessments were inadequate or improperly implemented. Now, this is the final slide for me. A blueprint for action. Now, that was the call in Allison against the London Underground in 2008. And I think 13 years on from that, it remains as valid as it was then. The suitability of the risk assessment has to be considered before the precautions taken are examined. So we need to look at what does it say before we see what did you actually do in practice. But when you're defending claims, as everyone will realise, implementation is absolutely key. What evidence is there of this? Now, employers can have the best laminated, fancy risk assessments, but if they sit on a folder up on a shelf and nobody ever knows about them or where to find them, they will not really be worth an awful lot evidentially. So I've heard of a risk assessment description fairly recently as it has to be a living, breathing document. I think that's as good a description as any. It strikes me it needs to be woven into the daily practice of a business and part of its operations, and needs to be kept updated and evolving. And when risks change or practices change, that needs to be reflected. But equally as importantly as being aware of the risk and how to manage that, it needs to be communicated to people. So if you're going to defend claims, there has to be evidence of that communication, whether you toolbox talks, sign-off sheets, video presentations, a PowerPoint presentation, something like this, some evidence that the employer can objectively point to as it identifying, managing and reducing risk in order to put itself in the best possible position 12 months down the line when a claim comes in to say, well, what more could we really have done here? Now, that is the end of my slides. I'm going to try and switch that off. Hopefully everything will come back on screen. I think in summary, we're 7 years on from the 2013 Act coming in. I think it was probably thought to herald more of a sea change than it has in practice. I think certain claims have been made much more difficult for pursuers. There's certainly more grounds to defend claims, but there's still an uncertainty about how you reconcile the extent to which the regulations will continue to apply and what standard your clients will be held to meet, even at the common law. So with all of that said, I think Lewis and I are quite happy to take any questions if anybody's still awake.
You do have to laugh, Mark, because I do remember when the 2013 Act was brought in. I think it was brought in to, in part, reduce the perceived red tape and the cost that businesses faced in complying with health and safety legislation. And I think it's quite clear that it's they're still working on that, given all of the different factors now you need to take into account when defending these sort of claims?
Absolutely. And I think what it is also a byproduct of it is that expert witnesses have rubbed their hands in cases, particularly where there's mechanical failures and it's engineering evidence that to get to the root cause of what's happened, more money has been spent on expert reports than hitherto would have been spent. So, and that's part of the evidence gathering exercise that both pursuers and defenders have to go through now to establish, well, what went wrong, why, what could you have done about it? And that one of the points Lewis was making about the 1969 Act, that's very important in those type of cases. So yes, more red tape rather than less red tape. Who would have thunk it?
Absolutely. Does anyone have any questions? I think they're all too busy thinking of the Scorpions window change. I think that's it. They're going through that in their mind. That'll be the earworm this afternoon. So thank you very much for that, Mark.
What I didn't say was that the window change was actually written apparently by the CIA as part of its propaganda effort to westernise Russia or the USSR. And there's a very good podcast on that, which I'm not an author of, but it's where I got all that from.
Well, you tuned in today, folks, to learn about employers' liability claims, but we offer much more when you tune into our webinars. You never know. Well, thank you so much, both of you. That was very informative. I thought it was very useful as well to give us a list of all the different things you would consider when you're defending these sort of claims. So if no one has any further questions, then we can sign off. But thank you once again for joining us.